Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Welcome to our Curious Amalgam. I'm Puja Patel, and today's episode is titled FTC versus DOJ, Who Wore It Better? Today, we'll take a deep dive into how the two U.S. antitrust agencies differ in tactic, style, legal standards, and processes, and how those differences can impact our work as practitioners. I'm joined today by my co-host, Barry Nigro. Hi, Barry.
Hi, Puja. I'm thrilled to be here. Would you like to go ahead and introduce our guest for today?
My pleasure. Joining us today is Debbie Majoras. Some would say an eyewit to an icon in antitrust law, and the perfect person to talk to us today about the inner workings of both agencies. Debbie previously served as the Deputy Assistant Attorney General at the DOJ's Antitrust Division from 2001 till 2003, and then as Chair of the Federal Trade Commission from 2004 to 2008. Following her FTC tenure, Debbie joined Procter & Gamble, where she served as Senior Vice President and General Counsel, and then as the Chief Legal Officer and Secretary until her retirement in 2022. Welcome, Debbie.
Hey, Puja, Barry, great to be here. Thanks so much for having me.
Hi, Debbie. To get started, why don't we start with some basics? And I thought a good place to start would be to talk about why the U.S. has two separate agencies essentially doing the same thing, enforcing the antitrust laws. The DOJ, of course, was the first antitrust enforcer with the passage of the Sherman Act in 1890. And then came the FTC in 1914, which was set up to serve as an expert agency and also an independent agency, although, as we may talk about later, that's come into question recently. What do you think are the benefits of this dual structure, and what are the downsides?
Yeah, it's a great question, Barry, because when we talk about this, when we've talked about it over the years, people have often debated, okay, we have this dual structure, here are the benefits, here are the disadvantages. Would we, if we could go back today, invent such a structure? And, there's views on all sides. And I think a lot of people would say no, but we have it, so we've made the best of it. I would say the benefits, a lot of people say, and this is really why the agency was established, that having an agency that is independent of the administration would mean that the agency would be less subject to lobbying and political influence. It has that independence. It has commissioners from both parties, at least it did. And so that independence, I think, was very important. Also, the FTC was given the ability to do research and to do studies and to really become an expert in various markets, whereas the DOJ has been more, not completely, but more of a pure enforcement agency, as evidenced by its criminal antitrust authority that it has. And then some people would probably say that having competition between the two has been somewhat beneficial. And I guess finally, people would say that there's an advantage to having an agency that has both competition and consumer protection together in its mandate. And I thought that was the case, but really worked to get those two bureaus working together more, because if that's to be the case, then there has to be some interaction and learning between the two. So I think those are really what people cite as the benefits.
And Debbie, sort of asking the flip side of that question, in recent years, there has been a renewed discussion of the One Agency Act, which proposes sort of consolidating the two antitrust agencies into one. Proponents of the act say that a single agency could create consistency and clarity. Meanwhile, I think opponents would say that, like you said, the FTC does benefit from some institutional independence. What is your take on the One Agency Act proposal?
Well, the first thing that I would say is there are definitely disadvantages to the structure we have. And obviously, if you look at the overlap in civil antitrust enforcement and merger enforcement, I would argue, and was very much a part of this on both sides, that the clearance process between the two agencies is an absolute embarrassment. And I don't mean because of any particular people who are part of it. It just is. So we have this overlapping jurisdiction, but without any signal from Congress as to how to divide that up. And so the agencies have tried to do it themselves. And in fact, back in 2001, when we were in a new administration, and I was at the Justice Department working for Charles James, Charles and Tim Muris were very good friends, and they were determined to fix this clearance debacle. And so we tried. Indeed, there was a civil antitrust complaint that had been sitting in clearance between the two agencies for 16 months. So both agencies thought this should be investigated, but neither would give in to the other. So when I talk about the embarrassment, this is what we're talking about. So, and by the way, we had to have we ended up mediating that, believe it or not. Charles made me mediate it. We won for the DOJ. I have a trophy, a boxing trophy as a result. And really, this is supposed to be good government. So when we tried to fix it, and I promise, Puja, this gets me to one of my main points about the One Agency Act. When we tried to fix it and we were dividing up industries, by and large, members of Congress went crazy on us and forbid us from doing it. And the reason that they forbid us from doing it is that certain industries that would have been, if you say, kind of under the jurisdiction of the commerce committees in Congress, if they went over to DOJ, would now be under the jurisdiction of judiciary committees and not commerce. And certain members of Congress didn't want to lose that, influence, if you will, to put it nicely. And so we were forbidden from actually fixing this big government problem. So my point about the One Agency Act is this. I think it would be very, very difficult to do. Maybe members of Congress have changed and they're not worried about which committee has jurisdiction over which industries and so forth. But that's definitely something that the proponents, I think, would have to get past. So there's a real question about whether that could get done. Obviously, there's a lot of hard things that aren't getting done in our legislature now. So I think there's a real question about that. I think the other question to ask, and this is delicate, and I take no pleasure in asking this question, but is the FTC really acting independently? I think that's a real question. I think some of us tried. So for example, when I was chairman, the White House policy folks were forbidden from talking to me unless they went through the White House counsel's office. And so definitely the White House set up, and I'm sure they did with other independent agencies as well. And so, we made a real effort. I tried to keep the White House apprised of things that were going to be in the news so that they would know about them. But there was very, very little interaction on cases that we had at the FTC. Is that the case now? You guys read the news and you can look at that and you can see how things maybe have evolved over time. So I think that's a genuine question to ask if we're looking at the one agency. But again, I have a feeling it just doesn't have a whole lot of chance of success.
Your comment about clearance and also independence of the FTC as compared to DOJ, has some interesting implications. I mean, just first of all, on the clearance front, everybody who's involved in antitrust enforcement at the FTC, at the DOJ, and the parties, nobody thinks that clearance process makes sense. It wastes valuable time. Resources are consumed at the agencies trying to resolve clearance disputes. As you described, I've been involved in some of those too. It's low-hanging fruit for DOJ, I think, and it's something that really should get fixed. But one of the implications of the whole clearance process is matters get assigned either to the FTC or DOJ, depending on how that process shakes out. And as you said, the FTC, to some extent, has approached things with an independent mind, and that, can result in an administration taking different approaches depending on whether you're at the FTC or DOJ. And a question is that a good thing or a bad thing? And so, I guess that, the question I have for you is, how have you sort of thought about that issue and some of the differences in terms of approach that the agencies take, depending on whether something ends up at the FTC or DOJ?
Well, Barry, it's such a great question. The first thing I would say is that there's no way that any result or even process should come about because of different standards at the agency. So, for example, the standard for preliminary injunction, which is a bit different between the FTC and DOJ when they go in to block a merger, we can argue, we can look at case law, and we can say, yeah, it's really not all that different. But the fact of the matter is, it shouldn't be different at all. Because one of the things that I feel very strongly about, especially having gone into in-house after I left the agencies, is not only if we want strong antitrust enforcement and we want to kill any competitive mergers before they ever get to the agency, and I'm sure both of you have killed some too, along with your in-house counsel colleagues, then we need a couple of things. We need transparency, we need consistency, and fairness. And it's really hard to explain to your business client that a coin flip in the clearance process might decide on your legal standard, and on the process. And if we're in the FTC, then even if we win the preliminary injunction, we might end up in administrative litigation. That's something that ought to get fixed. It should not be the result of a coin flip. And listen, the two agencies have done their best on clearance. I mean, we don't always have the greatest record to show for it, and people's desires, and I'm sure mine did too, get into that competitive spirit of wanting to take on a matter yourselves. But that process is not a good one, and having any different processes or standards in mergers or any other kind of antitrust, that needs to change. That I do think is a problem.
One of the challenges, as somebody who advises companies on M&A deals, if you have one of those deals where it's unclear which agency it might end up with, mm-hmm. and you're trying to figure out, what long stop date should we use if it's a transaction that, could end up in litigation. If you're at DOJ, you know that you go to court, the judge is going to, decide the preliminary injunction and combine that with a permanent injunction proceeding, and that's the end of it. At the FTC, even if the parties win the preliminary injunction proceeding, you could still end up in administrative litigation, and at the end of that, having to unwind the transaction, and so those sorts of procedural differences can have real, create real risk especially for the acquiring party that ends up having to close the deal and continuing to litigate the lawfulness of it with the FTC in a Part 3 proceeding.
No, most definitely not. It just adds a whole new layer of uncertainty to the process. And remember, uncertainty is what businesses have the most problems living with, right? I mean, businesses can put up with a lot. Most mergers are not absolutely essential to their health. Some may be, but most aren't. And so, knowing the answer becomes the most, as quickly as possible, becomes the most important part for sure. And this just adds another layer of uncertainty. And as I would add, and again, a layer of what is going on in our government. Is this random? I mean, I always wanted my business partners to really be able to trust what was going on. That was the way I could most ensure their willingness to work hard at compliance. And it's just harder to do if the whole thing starts to seem random or unfair. So I think, I think the actual people doing the work try to make it fair and not so random by and large. And by the way, I would make one other point about independence. The Department of Justice, when I was there, operated pretty independently from the rest of the administration. It's not a problem constitutionally for the administration to assert its will. The Justice Department is part of the executive branch, but kind of just based on longtime practice and tradition, the agency was also fairly independent. And, we didn't take really kindly to political influence. And I don't think anybody really likes it today either. But as we're reading in the media recently, there seems to be some of that going on.
So while there's a lot of overlap between the agencies when it comes to antitrust enforcement, there are also some statutory differences. For example, the Department of Justice has sole authority for criminal enforcement of the antitrust laws. The FTC, on the other hand, has Section 5 authority, which, at least under the Biden administration, was interpreted to be much broader than the Sherman Act. What are the implications for those statutory differences in enforcement authority?
Yeah, I don't think that the DOJ having sole jurisdiction over criminal cases makes a big difference. I mean, obviously there's the DOJ then has the ability to look at particular conduct and say, does this rise to the level of criminal, or if not, maybe would rise to the level of civil, can talk to colleagues and see about them taking on the matter. But in fact, if the two agencies are working together as they ought to be, if the FTC in the flip side case were to see something that they thought, and this happens once in a while, right? Perhaps when reviewing documents in a merger context and so forth, say, hey, could this be some kind of collusion? Ought to be calling the Justice Department and say, hey, would you take a look at this? And that's another thing, Barry and Puja, when we talk about these two agencies working on some of the same types of antitrust matters, they ought to be talking to each other and they ought to be working together. And I know when I was at the FTC, I really tried to foster that by having some retreats with leadership in both places so they would know each other. Because when you know each other, you're more likely to pick up the phone and call. So that's on the criminal side. On the Section 5 side, it really just depends on how the agency is interpreting Section 5. As you alluded to, Barry, for decades, we interpreted it as being almost completely on all fours with the Sherman Act and Clayton Act, with a couple of small exceptions, but we kept it pretty cabined in. Opening that up does raise a really good question about whether, another question to add onto the ledger of, does it make sense to have two agencies when one can enforce very differently from the other? Some people might say, hey, no big deal if DOJ can't do it, but they think it might be an unfair competition act, they can shoot it over to the FTC. But again, it really does get down to, gosh, what are we doing here? I mean, if a coin flip can decide what your statute is that gets applied to you, that's probably not the best way to be credible in our enforcement. So I do think that this is something that really I think requires a deeper look and query whether that will actually happen in the proposed legislation.
Debbie, you mentioned the retreats, which actually leads me to my next question. You've served in leadership positions at both agencies, and I would be really curious to hear from you and how you think the two agencies differ in terms of just culture and style. I mean, they are two different organizations at the end of the day.
Yes. The first thing I would say, Puja, is I think as I look back, they're actually more alike than different in culture and style. And I don't know whether they would be pleased to hear that I say that or not. But listen, I really mean this, that they're very, in both places, the culture is one of great pride in the work that people do, really believing that the work they're doing is worth doing and that they're making a difference, an important difference in our society by working to keep our economy competitive and fair. So that, I think, really transcends a lot of other things. They're competitive with each other. It's part of the reason why the clearance process is so difficult. But again, people it's good to have people who are enthusiastic about taking on tough matters, and they are that, to be sure. I guess that to some degree, and I wouldn't say I'm splitting hairs, but these are smaller nuances. The DOJ definitely has a culture that's a little bit more of a prosecutorial style, I think, that mindset, not surprisingly, given that environment of the larger Justice Department and the fact that they do criminal cases. So a little bit of that, I think, whereas perhaps the FTC has a culture that you feel that's maybe a little bit more regulatory minded, with the ability to do the studies and the rulemakings, and just having, yes, prosecutorial enforcement authority under some circumstances, but also having a wider toolbox beyond the prosecutorial tools. So I would say that has some impact. It's not a huge one. I said earlier, I do think that at least for a long time, DOJ also had a fairly independent mindset as compared to the FTC. The FTC obviously takes its independence very, very seriously. But I would say at DOJ, because it's a more vertical leadership structure, there's a little bit greater acceptance, perhaps, of how things move kind of up through the decision-making chain. What you can see at FTC is a little bit more independence in, hey, we're not going to accept perhaps that my manager thinks we shouldn't bring this case, and maybe I can go to lobby a commissioner who might be interested in this. And it seems like there's a little bit more, people see a little bit more flexibility in terms of how they can influence decision-making. And then finally, FTC has the consumer protection which is half the agency. And so, definitely there's no question that at Antitrust Division, people rightly believe that they're protecting consumers in the work they do. The FTC, based not only on antitrust, but on all the consumer protection work, you can feel how close people feel to the consumers. And that sort of infiltrates a little bit, I would say, the culture.
And kind of related to that, Debbie, just in terms of the organization, you talked about how DOJ tends to be a little bit more sort of linear at the top. There's also a little bit of differences in how they're organized more towards the bottom, too, with the FTC having the 3 bureaus. You mentioned consumer protection, DOJ more sort of organized in terms of sections, which sort of split by industry. I want to hear from you, how do those organizational differences, to what extent, I guess, do they impact the ways attorneys and economists collaborate with one another, the cultures of the agencies?
Yeah, it's a good question, because FTC is also within a bureau organized according to either industries or types of work. So it's definitely has some similarities in how they're organized. I would say when you have separate bureaus who are giving, it's very much a given that they would give separate recommendations. There's you feel a little bit more independence there, perhaps among the bureaus. It was a little bit maddening if you felt that the bureaus weren't interacting with each other as much as they should be, particularly in something, a few things came up in antitrust that also had consumer protection implications. And if you ask the question, did you talk to each other? And the answer is no. It's like, well, you can't keep citing this advantage of having both under one roof if you're not talking to each other. And that didn't happen a lot. By and large, we had some good communication across the lines. But I think really that those constructs for setting up the agencies, neither one is perfect. I always say this about setting up organizations. You do the best you can. There's no construct that's perfect. You'd have chaos if you didn't set it up at all. And the key is, do you move across the lines when you need to move across the lines? And most organizations I've been in, even outside of government, people don't always do that very well, and they tend to kind of stay with their hoard. And part of that is just because people are busy. But I think in both agencies, I don't think those lines were really prohibiting any kind of good cooperation. other than what you get a little bit with human beings from time to time. So I don't think that those constructs are really what makes a huge difference in the style, culture, the way they conduct their businesses.
There's also obviously differences at the top, with FTC having a 5-commissioner structure with the front office sitting beneath them, and then DOJ having sort of the individual DAG. I'm curious if that has any impact on decision-making processes. Is there sort of one process that you think leads to more
Puja, you froze.
better deliberations or institutional processes? And sort of related to that in the FTC, what role did you see the minority commissioners play?
Yeah, as opposed to what I just said about, I didn't think the structure of the sections and the bureaus made a huge difference in culture and decision making. The different structures at the top of both agencies make a huge difference in decision making. Now, I can't say that the decisions would have been different if you went to one place or the other. That is a lot more difficult to say, but in terms of how you get there, vastly different. So, but what I would, and I'll explain that in a second, but the one point I want to make sure I make is that deliberation was very robust in both agencies. So some people would argue and be worried that if you have an agency that doesn't have the construct of the FTC with commissioners from different parties, that you won't get robust debate and different viewpoints. That certainly was not my experience when I was at DOJ. We had a lot of different viewpoints on every matter that we seriously discussed. So that's kind of an issue, just my experience. Others may have had different ones. And the other thing I'll say is that when I was at the Justice Department, the Attorney General and really the folks outside the Antitrust Division, with a small exception here and there with the Associate Attorney General, really did not engage in our matters. In fact, it was funny when we first got to DOJ in 2001, and we had the Microsoft matter, which had just come back from appeal, where the Court of Appeals had dismissed large chunks of that case. I had to go brief the Attorney General from time to time with no aides of his, because everyone was recused because they all had technology stocks. And he didn't tell us anything except do what you think is right under the law. And so really, I wouldn't say we were on an island by any means, and we had to brief people and let them know what we were doing. But we really did operate mostly within our own scope. And when the Assistant Attorney General made a decision, by and large, that was it. Making's harder at the FTC. It just is, just because of the 5-commissioner structure, and that leads people to thinking, gosh, do I need to have my own viewpoint here? Can I go with the flow? Do I need to be standing up for some other principle? All of which is completely fair. But to tell you the truth, I remember thinking in my last year, I have spent about a quarter of my time in shuttle diplomacy between commissioner offices. And that was for 2 reasons. One, obviously, is structural. The Sunshine Act prohibits us from doing what you would do at DOJ and a lot of other agencies, which is get the people with differing viewpoints together, for crying out loud, and start hashing it out. That's a really important thing to do. And of course, at the FTC, you can't do that with more than 2 commissioners unless you want to call a public meeting. And so you end up doing, as I did, a lot of shuttle diplomacy. And the second reason why I did so much shuttle diplomacy was because I believed, and not everyone does, that getting as many 5-0 or even 4-1 votes as we could was really important. And really important for the reasons we talked about previously, which is companies and others in the marketplace deserve to know what the rules of the game are. And if we're setting the rules of the game, we need to be transparent, we need to be consistent. And it's just really hard if you have if you're constantly having split decisions. So that was sort of my philosophy, was that it was really good for law enforcement to try to get as many as many 5-0 votes as we could. And I think we largely succeeded. I think we had a lot of them. In consumer protection side, we had very few where we didn't all agree. But of course, we had some where we disagreed in antitrust. So I think that some, and people can argue that the FTC ultimately reaches better decisions by having that. I would leave that for other people to say. I'm just telling you that it is harder. It is harder to get to decisions. Now, on the role of minority commissioners, I was very fortunate. I had 2 minority commissioners with whom I had really strong relationships. Pam Harbert and I had known each other for a long time, and John Leibowitz and I were tied together in the confirmation process. And if there's one way to get to know somebody well, it's to sit in a congressional hearing where you're getting yelled at together. So I had very good relationships with them, which isn't to say that we always agreed. In fact, I remember the first time that Pam and I really had a disagreement on a matter, and we just couldn't come to agreement. And she came in the next morning and said, and I'm sure she wouldn't mind me saying this, and said, "This is so awful. I couldn't sleep last night. I felt like I just had my first fight with my boyfriend." So we were very cordial and I think very respectful. But obviously, people have their views. So, being in the minority, I think people who are in the minority feel a certain responsibility to make sure that opposing views are being aired, even if they aren't the views that rule the day. But that actually helps people, think through and perhaps in another matter where the facts might be a little bit different, perhaps the conclusion then for the commission is a little bit different.
Before we close out, we wanted to go through a rapid fire session with you. And to start, where do you feel the front office had more day-to-day involvement?
I don't think it was different in either one. I think the front offices in both, they were a little bit different in structure and number of political folks versus career folks, but I worked very closely with both.
Yeah, that was my experience too, having been at both agencies.
Debbie, what do you think is more fun where do you think is more fun to litigate a case? FTC administrative court or federal court with the DOJ?
Oh, gosh. I think, and I live with a litigator, so I should have asked him. But I think for both, the part in federal court is the most fun. It's very public. It's very out there. I think it's actually, while some people wouldn't call it fun, it's obviously good to get a neutral to put their eyes on your case and your thinking. And, it's a very healthy exercise and very challenging at times. And so I think, with all due respect to the ALJs and the administrative process, I think federal court is pretty cool for most folks.
And what's the hardest decision you made as FTC chair?
Oh, gosh. There's a few I could give you. I think there's a civil conduct case that the commission brought called N-Data. And it was the first and fortunately only case in which I dissented. Don't normally see the chairman dissenting. And in fact, some of my people pushed me really hard to find a way not to dissent because they said to me, "We're just so afraid it'll look like you've lost, control of the commission." The case represented a change in policy, and the change in policy really was use of Section 5 in an antitrust matter standalone without Sherman Act or Clayton Act claim in an area where we hadn't previously used it, which had to do with standard setting and IP. So that was hard. You don't like to be in that position, I think, when you're running the agency. But my feeling was I would rather stand up for the position that I think is right. And if people want to say that means I've lost control, they could say that and do what I thought was the principled thing. And I wrote a respectful dissent, the only time I ever had to do that.
Maybe you should have cleared that one to DOJ.
Yeah, maybe I should have cleared that one to DOJ. The other one that was kind of hard for me, guys, to tell you the truth, was Whole Foods and Wild Oats. Because I had always told the team that our only job at the FTC is to look at the facts, apply the law and the guidelines to the facts, and take it where it goes, right? Under that. And even though the guidelines suggested that we should bring that case, I just didn't want to bring the case. I was under a lot of pressure about urban areas not having good grocery stores, and wasn't there something we could do about that? Which of course there really wasn't something the FTC could stand alone do about that. But then I was saying, okay, so I can't do anything about that, and now I'm going to bring the case to protect the people who will pay $10 for a head of lettuce. I mean, but the team did what they should do, and they said, Chairman Majoras, you said we're going to bring the cases that result from the analysis, and so we brought the case.
Debbie, what is one piece of advice you have for the next generation of enforcers?
Yeah, I would just say, going in, think about your goals and your principles, and if it's market competitiveness to the benefit of consumers, then think about how you best get that done. That means I think you want to influence companies to play by the rules. So they need to know the rules. They need you to be transparent. How do you best ensure that? Think that through. They need to believe that the rules are fair and that they're being fairly applied. So work hard on that. If it seems random, as I said earlier, then you lose people in compliance. And I think the most important foundation for compliance and therefore competitiveness could get lost when people think that it's not fair and it's too random. Of course, this is going to mean that you're going to bring some significant cases because that's our system of law. But if all you want to do is bring big splashy cases that get lots of headlines, then I would just say, why don't you go do something else?
So FTC, DOJ, who wore it better? If you had to step off the golf course and go back to one agency tomorrow, which one would you pick?
I would pick the one that I believed at the time I could stand up for principle and competitiveness and consumers with least interference from people who had other goals in mind. That's all I'm going to say.
Okay. So before we close out, this is the fun part of the show, and we just have two more questions for you. Tell us something about yourself we would not know if we only knew you in a professional setting.
Well, very. Be careful here. No, I guess one of the things I would say is I grew up painfully shy, and I'm actually very introverted. And I love people, so I learned how to get out of my shell, but all of you exhaust me.
Okay, Debbie. And now we're going to turn to our last segment, which is called The Curious Hat.
And now it's time for The Curious Hat.
All right. I'm pulling from the hat, Debbie. What was the last good book that you read?
Oh, gosh. I read a lot. I read a good book called There Are Rivers in the Sky.
What was that one about?
It's about Mesopotamia and various periods in its history, but people who lived at that time and how that history all gets strung together. And it's done through the river, thinking through the rivers and others who live near rivers and streams. I know it sounds a little strange, but it's actually a really good book.
And did they have one enforcement agency or two?
There is one of the characters in the book works at an agency that works on the water streams in an urban area. So yes, there's a little bit of regulatory in this book.
Well, Debbie, thank you for joining Puja and myself for our Curious Amalgam. It's been a wonderful discussion, and to our audience, we look forward to seeing you next week.
Thank you for listening to this week's episode of our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.